Greetings, 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 greetings. It is I, your king, King Clifford Jefferson, ascended from the house of Plantation on the Godfrey, the fifth count of Anjou, the son of folk, ruler of Jerusalem. I am the reincarnation of he who you call Jesus Christ. We name him or call him by his name, King Edgar the Peaceful, better known to you all or us all as the King of Peace. We greet you in the name of our ancestors. We greet you in the name of their laws. We greet you in the love of their spirit, and which still flows through us through our blood. We're here today with another marvelous lesson. We greet you in the absence of Archbishop Belmont from the House of Belmont, as well as the CA Coadjutor from the House of Murphy. We don't know if he's going to make it today, but if not, we greet him in love. And we just give honor to our other officers, Sister Allen from the House of Allen, as well as Sister Jones from the House of Jones, Brother Middleton from the House of Middleton, our partner self, Sister Jones, Sister from the House of Middleton, Sister Jones, Sister Middleton, Brother Means from the House of Means, and everyone else here, Brother Gray from the House of Gray, Brother Scott from the House of Scott, Sister Harris from the House of Harris, Countess Walker from the House of Walker. Greetings this morning.
Greetings.
That's Countess Walker. Can I hear you? Greetings, Brother Milligan from the House of Milligan. I think that's him. 917. Greetings to you all. Okay, Sister Walker, greetings.
Greetings, Countess Walker.
Greetings,
Countess Walker.
All right. Everybody's here. That's a good. Let's get ready to go. Once again, I'm your king, Clifford Jefferson. Who is that tapping on? That's Brother Milligan.
Yes, King.
Greetings. Welcome to today's class, brother. Thank you for your stewardship.
Thanks, King.
You're welcome. Let's get started without further ado. Once again, greeting, I'm your king. Welcome again to the English Temple Church in the absence of Archbishop from the House of Belmont, as well as Coadjutor from the House of Murphy. I am your king again. This is your Queen, Sister Godwinson. And in the spirit of English Temple Church, I give her a couple of minutes to say a couple of words, as well as just give everybody a couple seconds to say good morning to everybody. And I digress. Queen.
Greetings, everyone. Greetings. Hope everyone had a blessed week. I want to start off by saying we are in dire times with all the issues that we have going on in the world today, from poverty, hunger. Another one is
Discrimination.
Violence, war, discrimination, government corruption. But the main one I want to talk about is human rights. And without a nationality or without a nation, you're always going to have issues regarding human rights. I just want to give honors to our king today, Clifford Jefferson.
Thank you, Queen.
And like I said, without a monarch, which gives you those rights and protection, you're going to always run into issues. And in order to receive those hereditaments or all those rights and become heirs, you have to pay allegiance to the monarch. And that all goes back to claiming the crown land, I should say, claiming the crown land, and everything that's comes along with that, whether it's property, fixtures, or anything else that's on the land. In order to rightfully claim it, you have to have an allegiance to a king.
Yes.
And with that, I want to say Great job to King Clifford Jefferson. I just want to give honors to you today. And with
Thank you.
that, I digress.
Thank you. That's well received. As you know, I do put in a lot of work, a lot of times, some hours, sometimes I don't even eat, because, you know, I survive off the food of the spirit of my ancestors. And I amazed myself that my body had been able to go through the turmoil. And as a result, what you sacrifice, you should receive. So I really appreciate, you know, the honor that you bestow upon me as not just being your king, but as well as your mate. You know, our ancestors have really sacrificed for the sake of family, and family membership, family participation is very important. It all comes in degrees. Like I said, you know, we grow in degrees, and sometimes the fire might be a little hot, fire might be a little cold, but we always got control of the fire. And that's what we need everybody else to know, that we determine our extent, our purpose as a family. We guarantee these rights, and that's based off our commitment to what they identify as citizenship. Citizenship is very important. By you being here today shows me that you have appreciation for citizenship, because citizenship means membership. Membership means partnership. Partnership means family. And no greater way that it could be expressed than any other way that could be expressed than to hear words from your family. And with that, I'll let Sister Militant from the House of Militant say good morning.
Greetings to you all. To camelback on the king and the queen, I think of my grandmother who says, when you raise your children, it's sacrifice, sacrifice, sacrifice. And she raised 9 children. So to all the energy that my grandparents put into my mother in particular and her siblings, it paid off, but it wasn't always easy during the times of the Depression and the World War II, and just not even being able to see in front of you. Sometimes it was just very dark. So I'm just, again, very appreciative to be here. The ancestors led me to this wonderful group organization, and look forward to the lesson. And I digress.
Well said, Sister Militant. You know, and I love that, you know, there's a lot of groups and organizations out there in the world today, you know, but the intent of those organizations or groups are not in the intent of us as citizens, you know, and it's very important to distinguish that when you say a group, because it becomes ambiguous. When it becomes ambiguous, it becomes abstract. When it becomes abstract, then that means it becomes wavery, and you can't build your house on sand. You got to be on the solid ground, you know. And I walked across those sands. I crossed those seas to make sure that when you came home from this crusade, that you will be on solid ground and forever be on solid ground. And solid ground has been solidified by solid law. Solid law written by solid people. When I say solid people, I mean solid, liquid, gas, ethereals, physical beings, Homo sapiens, etc. But we're all guided by our spark of life. That's just sacredness. That's in our blood. That's the vehicle in which our ancestors travel down through us, through our genetic ancestors, through our blood. And our lesson today is going to prove that. So well said, Sister Middleton. We now get the floor open to Sister Harris. Good morning, Sister Harris from the House of Harris.
Good morning, Queen. Good morning, King. I'm looking forward to the lesson as every Sunday. I'm grateful to what you're providing for us as a family and elevating us. As you said in one video, we are here to learn, we're here to grow, and we're not supposed to be here being comfortable. We're supposed to be getting better and elevating, rising, learning this and teaching others. Thank you for today.
Well said, Sister Harris from the House of Harris. Brother Murphy, Brother Monday from the House of Monday. Never mind, you're good to go. All right, good to go. Brother Walter.
How you doing?
Right. Brother
Peace
Walter.
and greetings. Peace and greetings.
Greetings. We'll get the chance to say, but I missed my place.
Go back to Sister Countess Walker.
Sister Walker, you were next.
Mhm.
Greetings, everyone. I'm
Greetings.
glad to be here. And I actually am very appreciative of this lessons and being here with the King, because I'm a mother, I'm a grandmother. And I actually think we are all here before our time. You know, I had some discussions with my husband about this, and he just don't get it. He don't get it. No matter how much I show him, his name is English, you know. He says he didn't marry an English woman.
Wow.
Yeah, he told me that the other day. He seems upset about this. And so it just lets me know, once again, I'm way ahead of my time. You know, things me and Sister Allen, we've been in this for many years, over a decade together. And me and her, we've been way ahead of our time. You know, a lot of things that we see people do now, me and her did 15 years ago, 10 years ago. Yes. So I know it's going to be a while before a lot of people catch up to where we are. And I'm very committed to what we're doing. And I'm very grateful for all the studies that the King is doing, the Queen is doing, Archbishop is doing, Archbishop CA is doing, because I haven't found any contradictions in anything that we've learned here. And so I'm glad to be here today. I'm glad for my commitment, because, you know, my family will see this. It may be 10 years from now, maybe 15 years from now, but they'll see what we're doing. So I am on the floor.
Well said, Sister Walker from the House of Walker. Like I said, you know, hearing the Countess speak, man, it's just revelation and wisdom that you are not a new species, you're an old species. You were the original one. And how you know that is because the stuff people have now, they don't know this. So that means that you knew on the scene. We the ancient ones. We go back to time immemorial. So once said, we're way ahead of our time. You're being reborn. You just woken up from the dead. And this is the time to awaken. So I couldn't have said it in a better way, Sister Walker from the House of Walker. Sister Allen, Countess Allen from the House of Allen, good morning.
Greetings. Good morning to everyone. Good morning to you, King, Queen. Give honors today. And I can't wait to dive into this marvelous lesson. You know, I was speaking to a good friend of mine, and he's part of a different group. I'm not going to say which one, but his leader fell ill, had a heart attack, and but he's okay. And it just, you know, it just made me think. I was like, well, what are you all going to do about it? You know, and they're so new in the things that they're trying to bring forward. You know, it just made me think. You know, I'm like, wow, this is very important. What we're doing, what we're embarking upon, what we're trying to bring to the world, and something so, you know, things that we don't even think about is, you know, our health and our well-being, you know, to be able to bring this message. You know, we have to be in the right state of mind. We have to be in good health. We have to take every necessary precaution, you know, to protect ourselves, you know, while we're pushing forward, you know, to bring this information, this glorious information to our people. So, you know, it was just a long time with me, you know, just reflecting on things that could befall any one of us, you know, and I just say, you know, everyone be at peace and take care of yourself, and, you know, and just do everything humanly possible to, you know, stay well. I love you all, and I digress.
Well said, Sister Allen from the House of Allen. Like I said, I try my best to take care of my health, in spite of what my queen say, with 2 cups of sugars. But I mean, that's not bad. 2 cups, I mean, that's not bad, you know. But you know, I'm pretty healthy. Well, let's say that for another day. Okay. Let's move on with that. We're gonna say that. Greetings. I think all of the countess spoke. Brother Gray from the House of Gray. Good morning.
Greetings, King. Greetings, Queen. And greetings to all who are on the channel. I'm looking very forward to getting this new lesson today. Seems like each week we delve deeper and deeper into it, and the more understanding we seem to gain from it. And I just look forward to see what you have for me, and I'm gonna digress and let the other brothers speak their piece.
Well said, Brother Gray from the House of Gray. Next, we have Brother Scott from the House of Scott. Good morning, Noble.
Unmute.
Can't hear you, Noble.
Brother Scott, you have to unmute your.
What about now? Can you guys hear me now?
We hear you well.
Okay, good. Greetings, King. Greetings, Queen. Greetings to everyone. Just to camelback off what the young ladies were speaking of, King always wonder, everybody's not going to understand this information or understand our mission. And I always wonder if it's our mission to save them or convince them, that type of thing. But I once heard that if you don't do anything, but you should declare your nationality. So I'm hoping we're going to go into that a little bit. And I always look forward to hearing what you guys have to say, because I learned so much. And I'm loyal to the church, and I'm looking forward to getting this business done. And, you know, a lot of us are older now, you know, King. So we definitely have to learn this information because we have to pass it along.
There you go.
And so that's where I think I'll benefit from learning to pass it to the younger generation, the ones that are really going to gravitate towards this information and absorb it. I digress.
Well said, Brother Scott. I mean, like I said, you know, we understand that they mimic us. You know, you have a paramount name, Brother Scott, and we know that Scott goes back to Captain Kirk. And, you know, Captain Kirk, that was a spaceship.
Mm-hmm.
And we know Kirk means church. And we know Spock was a Vulcan. And I'm not mistaken, Spock was a Vulcan.
Yes.
And we know Vulcans are symbolic to, as archbishops say, Albion, or the elves, you know. And I mean, I have such a marvelous lesson for y'all today. It's just like gonna be mind-boggling. So I'm not gonna wait, because we have somebody new in the house. Brother Walter from the House of Walter, and his queen, his countess. Good morning. Good morning.
Grand Rising, everyone. Grand Rising family. Thank you for allowing us to be here this day. We wasn't here last week. I had some family things going on last week, but this is my queen.
Welcome.
Countess Meriwether. It's her last name, and she is an English woman. We have done some research, and she loves being an English woman too. So she wanted to be here today, along with the family. And greetings to you, King and Queen, Brother Murphy, and Archbishop. Thank you so much for making sure I'm in here today. So
we got you, Queen. Make sure I do my job.
Yeah.
To make sure I do my job. So it ain't nothing like having people in your corner. To have y'all here every morning, it's just a blessing, you know. It just quantifies our growth, you know, to see y'all grow, you know, because without leaders, we have no followers. Without followers, we have no leaders. We all serve the same purpose, and the only purpose is to grow. So well said.
Brother Mundi.
Brother Munde, good morning, Brother Munde from the House of Munde.
Peace and greetings, King.
Greetings.
Peace and greetings.
Hold on.
Everybody.
I pardon myself, Brother Munde. I wanted to give Countess Walthor, Countess a chance to say good morning.
Okay.
I apologize for that, Countess.
Grand Rising.
Grand Rising.
Good afternoon, everyone. Grand Rising.
Okay.
Greetings.
Greetings. Good to have you here this morning.
Greetings.
You feel free to talk. Any comments? Feel free to let us know. We indulge the conversation, and we hope that we won't let you down with our presentation today. Okay. Welcome again.
Sounds great. Thank you so much.
You're welcome. our brother Monday from the House of Monday. Greetings, good morning, brother.
Peace and greetings, King and Queen, and everybody.
You're welcome. Good morning. I was gonna get you about that T-shirt, but you caught me.
Oh, my shirt. My shirt.
You caught me. I was gonna get you. You caught me.
Yeah, I gotta find a. Yeah, I got a whole bunch of designer shirts. I gotta get some plain shirts. So, you know, I gotta step my game up and get
It's
right.
all right. It's noted.
With my attire.
It's noted.
How everybody doing? Peace and greetings to everybody and King and Queen, and thank y'all for letting me be here. Had a lot of things going on with family reunions and graduations, and you know, everybody being great. You know, so but I'm here.
Hey,
today
that's
for
a
this
family
marvelous
man.
session.
That's a family man.
Yeah,
That's your
I'm here.
job. You can't neglect your present concern. He who does
And I
that
got
throw
this- I
away
got-
everything he has.
I got this concession business I just started. So I had to build the trailer, get the trailer, and order all the stuff, and I got a lot going on. But I'm here.
Okay.
I'm here. You know.
We can use that. We can use that skill, brother. Well said. Good to have you again. Thank you for your stewardship. Let's have Brother Militant from the House of Militant. Good morning, Rastafari.
Good morning, Jed.
Easy, Ross. That's my man right
Yes,
there. How you feeling this
you know,
morning?
the Queen. Oh, pretty good, King. Pretty good.
Okay.
Yeah. You know, the Queen mentioned something about nationality. And it's actually very important because, you know, a lot of people think black and all that stuff, African American, trying to soup it up, make it sound like a nationality. And I'll give a quick little example. Some Nigerians ran into my fence. I don't know how the car went up into my fence and knocked it down. They were drunk, like two skunks, real drunk. The cops came and they didn't even give them a ticket, nothing. And I'm sure if it was two black Americans, so to speak, that happened to, they would be in handcuffs. You know, and like the king said, he who names you, claim you. And the Europeans named us Negro and Black, not as a compliment, but as a slave brand name. And therefore, being that we using it, and they say anything you say can be used against you in a court of law. That's what we use.
Subject matter.
And they
boy.
claim, you know, they claiming that to be their slave property brand. And you could look at that in the 1740 Negro Act and the Dred Scott decision that we wasn't even intended to be citizens, let alone national or whatever here. So we got our own thing from 927 with Athelstan, first king, or
Noble Stone.
incorporation.
Oh, we're going to
That's
talk
right.
about him today, brother. We're going to talk about him today. You best believe that. We're going to get this
but, you know, okay, I ain't going to go too long-winded, maybe another time, but I know you got a great lesson for us, so let's, you know, get on with it.
Yes.
Thank you.
Well said. Well said. And last but not least, Brother Means from the House of Means. He's the one closing the doors for the English Third Temple Church today. So all those who are not able to make it today, I hope you're able to meet me here in spirit and honor, as well as do this podcast after it's being posted. But with that, we'll get on to this marvelous meeting. You got the last word, Brother Means from the House of Means.
Grand Rising, greetings to everyone. Pleased to be here. Nice to see you all smiling faces. I'll try to make this short and sweet, but I noticed something with everyone's comments and their greetings, and it was awesome to hear the connectivity that we have in a spiritual frequency, because all of this is interlinked into one, and you can tell from the energy that the King and Queen has come with. I would like to say that from everyone's comments that as far as from the King, when he said you traveled the waters and through the sand, and going through all these different changes and these different groups, use it as a learning tool. It was the process for us to get here. And now that we're here, it goes back to Mother Jones, Millicent was speaking of the grandparents. That's the foundation to anchor everyone's home. And whether it was your mother's mother or your father's mother, whatever their upbringing was, it brought us to this time. And only those who will pay attention and were receiving those hardships, they were out of love. Those blessings, they were out of love. Those teachings that we got to organize us and formulate us to this situation, because one day they knew this day was going to come. We probably didn't know, but they knew. I will speak personally from my grandmother, my mother's mother, is because she was so formal. We had to call her grandmother. There was nothing else that she would allow us to call her. And I was always wanting grandmother. Well, her thing was this: you always be proper, but she would always drop nuggets of us how to act and how to, be in public and represent the home. Because if you don't act that way at home, you don't act that way in public. And those things that were taken from you can be brought back to you if you be studious to your time. So yes, we travel through all these different avenues, looking for information, of trying to find ourselves and reconnect ourselves to our ancient ancestors, the true ancestors. And it's remarkable to be here and hear these words come out of everyone's mouth. But I would like to just say it's beautiful to see that we've come to this time now, and it's not too early, but it's right on time. Those that are not comprehended, is not meant for them. Everyone's alarm clock go off at a different time. Our clock went off at the time that was set for us, and we've amplified that clock, got up and doing the studious work. So again, I think it's a marvelous time to be here. I appreciate the opportunity to be amongst like minds. So again, I would say Grand Rising, and I yield.
Well said, Brother Means from the House of Means. Everybody spoke intelligent, and we know with intelligence comes growth. Our forefathers were the ones who declared us to be the heirs and successors, and that comes to our nationality. And I come with a marvelous lesson, and without further ado, let's get started. Okay, we want to give honor once again to Archbishop Belmont from the House of Belmont for his marvelous job as a mediator, and to make sure that everybody's being able to attend this beautiful class today in the absence of his sickness. We love you, brother. We wish you well. We're trying not to have you or hold you long, but you know how we are as English people, we long-winded, so just stay on mute. If you doze off, we'll shoot your email. If not, then I guess we'll be on here all day till you wake up. But with that, let's get started. All right, nationality. Let's see. Don't start giving me problems. Come on. Okay, here we go. Oh boy. Yeah, I gotta bear with me. Okay, here we go. I'm gonna ask for participation. So when I call upon you, I'll tell you when to stop. First on the scene, Brother Means. This dealing with United States nationality law. Very important. Before we go here, let's just get a narrative. We want to get a narrative in regards to citizenship. How it's deciphered or determined here in what we call the United States. When we say United States, we're saying North America. And we know citizenship deals with natural born citizenship, being naturally born here on the soil. We call that just soil, being born of the soil. Once again, just soil meaning being born of the soil. It's not dealing with just ingredients by blood, just soil. And we know when we're dealing with United States citizenship, their citizenship denotes to nationality. So when you become a United States citizen, you're national by way of naturalization. That's your nationality, is by way of naturalization. Now, this happened through the 1790 Naturalization Act. Before that, it was called the Plantation Act of 1740, or the Naturalization Act of 1740. This is called a letter patent, which is a note to what we call a citizen. What is a citizen? A citizen is a person who is given citizenship. It's not even taking into account being slave or not a slave. They're talking about citizenship. Yeah. When you're a citizen, you can either be a national or foreign national. A national means that you're a citizen of a nation, i.e. a country. That's where your allegiance goes to, and that's where your protection comes from. That's a contract. That's an agreement. Here in the United States, nationality denotes to naturalization because you were granted the right to become a citizen by way of incorporation. That's a grant. It happened in 1790 with the founding fathers within the District of Columbia. Then it happened again with the 1865 when they emancipated so-called slaves, which means that they discharged you from being a slavery or chattel and now made you free. It said nothing about citizenship. Now, Dred Scott was assumed to be a citizen according to the Constitution, not even according to the Civil Rights Act, because he was free from slavery, but he didn't have the protection under the Civil Rights Act in regards to those that white people had. Everybody understand?
Follow.
Okay. Let's read for me, brother Means. Can everybody see the screen, first of all?
Yes.
Let's blow it out.
Yes,
Let's blow it
please.
out.
Yes.
Okay, go ahead.
Overview, natural born citizen. A natural born citizen.
Sorry about that. Sorry about that.
That's okay. It's okay. It moved though. Okay. There you go. Natural born citizen overview. A natural born citizen refers to someone who was a U.S. citizen at birth and did not need to go through a naturalization proceeding later in life. Political office requirements. The phrase natural born citizen appears in the U.S. Constitution. In order to become the president or vice president of the United States, a person must be a natural born citizen. This natural born citizen clause is located in Section 1, Article 2 of the United States Constitution. The Constitution does not expressly define natural born, nor has the Supreme Court ever ruled precisely upon its meaning. One can be a citizen while not being a natural born citizen if, for example, that person gains citizenship through the process of naturalization. Under the 14th Amendment's naturalization clause in Supreme Court case of the United States versus
Hold
Wong
on,
Kim
brother.
Ark.
Somebody
Okay.
put their phone on mute. I hear a lot of background noise. Okay, go ahead.
All right. Under the 14th Amendment's naturalization clause, the United States Supreme Court case of the United States versus Wong Kim Ark, 169 U.S. 649. Anyone born on U.S. soil and subject to its jurisdiction is a natural born citizen, regardless of parental citizenship. This type of citizenship is referred to as birthright citizenship.
Did y'all hear that? Did y'all hear that?
Yes.
Birthright citizenship. Now they talking about 14th Amendment naturalization clause. It's supported by a Supreme Court case in regards to just soil. And they call it just soil a birthright.
Yeah, it's not. That's contradictory.
That ain't right. Something wrong with that.
Yeah,
We need to look out for that. Continue to read.
sure. There is some debate over whether or not one may also be a natural born citizen if, despite a birth on foreign soil, U.S. citizenship immediately passes from the person's parents. Today, 8 U.S.C. subsection 1101 defines naturalization as conferring of nationality of a state upon persons after birth by any means whatsoever. In
Any
contrast, yeah,
Did you see that? It said any means, y'all.
yeah. Yeah, this deceptive. In contrast, subsection 1401 lists 8 categories of peoples who are national, and citizens of the United States at birth, including those born in the United States and subject to its jurisdiction, as well as children of one or more U.S. citizens abroad, as long as the parents meet certain requirements. This means that foreign-born citizens falling under the provisions of 1401 are, by statutory definition, not naturalized. The term natural born is not used. However,
Stop right there.
okay.
So as we can see, in lieu of the narrative as explained by legal information based off Cornwell, it states that a natural born citizen refers to someone who was a U.S. citizen at birth and did not need to go through a naturalization proceeding later in life. How we know that? Because you got a birth certificate.
Yes.
That's your form of citizenship. And that denotes to allegiance. How we know that? Let's get a little more formative about United States nationality law. Continue to read. Everybody look, United States nationality law, we know when they say nationality, they're not talking about us, because they talk about naturalized citizens or citizens or national or foreign nationals. So once again, a naturalized citizen is a foreign national or naturalized citizen or a citizen. One and the same. You're a colonist.
Yeah.
You were originally here. You came from somewhere else and colonized here. Continue to be here, Brother Means.
United States nationality law details the condition in which a person holds United States nationality. In the United States, nationality is typically obtained through provisions in the U.S. Constitution, various laws, and international agreements. Citizenship is a right, not a privilege.
Read that again.
In the United States, nationality is typically obtained through provisions in the U.S. Constitution, various laws, and international agreements. Citizenship is a right, not a privilege. While the domestic documents often use citizenship and nationality interchangeably, nationality refers to the legal means in which a person obtains a national identity and formal membership in a nation, and citizenship refers to the relationship held by nationals who are also citizens. Individuals born in any of the 50 U.S. states, the District of Columbia, or almost any inhabited territory are natural-born United States citizens. The sole exception is an American Samoan, where individuals are typically non-citizens, U.S. nationals at birth. Foreign nationals living in any state or qualified territory may naturalize after becoming permanent residents and meeting a residence requirement, normally 5 years.
Stop right there. So now we're talking about citizenship under the guise national, but actually a naturalized citizen within the 50 states of the United States. And we know before you had the 50 states, you had 13 colonies.
Correct.
Right? Which we know that if you're a colonist, you're a foreigner.
You're foreign.
If you're a foreigner, that means you're a citizen. If you're a citizen, then you're not in there. All right? Now just get a breakdown before we really get down in detail. Just speed up in time, history. Now, we already know, read this first line right here, y'all. Our brother Means.
Sure. Nationality Law 1790-1866. The first statute to define nationality and naturalization in the United States was the Naturalization Act of 1790.
Keep reading.
Okay. It limited those who were eligible to be nationals as free white persons.
Stop. Okay. And it say nothing about Negro, black, colored, Ethiopian, bond servants, chattel, etc. It says white persons. Now, all those who are viewing this podcast or will be viewing this podcast, it's not about discrimination. This is not about talking about people. This is about clearing up the confusion in lieu of identity in regards to a nationality here in what we call North America, because North America is not really called North America. North America is actually England. And England, the nationality for English people are English.
Yes.
Why? Because the country. All right. Now, there's only two people can be here, either the colonists or the English, because those monarchs who were sitting on the throne of the English were also colonists as well. If you read our previous classes. Now, how we know they were colonists, just a quick snapback, Nationalization Act of 1790. Okay, read this first paragraph, Brother Means.
Sure. The Naturalization Act of 1790, enacted March 26, 1790, was a law of the United States Congress that set the first uniform rules for granting the United States citizenship by naturalization. The law limited naturalization to free white persons of good character, thus excluding Native Americans, indentured servants, slaves, free Black people, and later Asians, although free Black people were allowed citizenship at the state level in a number of states. The act was modeled on the Plantation Act of 1740 with respect to time, oath of allegiance, process of swearing before a judge, etc.
Read that last paragraph before.
Sure. The last paragraph or last sentence?
The last paragraph. We already know they ain't talking about us. So
Yeah.
we ain't blacks, we ain't into servitude, we're not Asians, we're not white.
Last sentence.
The last sentence is said here. Now the Nationality
okay.
Act of 1790, which that include us, it just spoke about specifically white. And it said that that model of term of citizenship evolved from the model called the Plantation Act of 1740.
Correct.
Now read that last sentence again for him, Brother Means.
Sure. The act was modeled on the Plantation Act 1740 with respect to time, oath of allegiance, process of swearing before a judge, etc.
Allegiance, y'all. Oath. That's talking about citizenship. But they're going back all the way to the Plantation Act. So what is the Plantation Act? Read that, Brother Means, in closing.
Plantation Act 1740. The Plantation Act of 1740 or the Naturalization Act 1740 are common names used for an act of the British Parliament that was officially titled on Act of Naturalization, such foreign Protestants and others therein mentioned, as are settled or shall settle in any of His Majesty's colonies in America.
Stop. That's all we need to read.
Yeah.
That's a painted picture for y'all.
Yeah.
That's the painted picture. Can everybody see that picture? Everybody see that picture. I don't need no explaining, do I?
No.
What about you, Countess, Sister House, Brother House of Walker? Your Countess, you need to explain on that explanation? Or was that simple?
You have to unmute yourself.
It was simply put. I would love to know exactly what your thoughts were, the picture that you wanted everyone to see.
Oh, I'm about to get there. I just want to make sure that was clear. I'm about to get there. Believe that. I'm about to get there. Okay, everybody else on the court. Okay, so we know we're talking about the Naturalization Act, which they call nationals. And we know that the nationals here are descended from that Naturalization Act of 1740, but deals with colonists. This is the reason why they're called foreign nationals or citizens, or what we call Naturalization Act. What they did was made you a citizen, well, via that birth certificate. Before you had a vital statistics, you had what they call GRO. GRO is the General Registration Office. After that, you had what they call the Birth and Death Registration Act of 1837. But before you had those two, you had what they call the Church of England. All persons born were registered in their city parishes. Now, we're going to have a problem with this. Why? Because this causes diversity of citizenship. Because we're not naturalized citizens. Why? Because we know there's a difference between, in America, a difference between a naturalized citizen and a national. And you know, and we're not nationalized citizens because we're English nationals. And we know English was here before the colonists got here. Right? So that means that we got to go back before the Nationality Act of 1740 in order to prove our claim. Because I said, he who writes your books sets your timeline. Okay, let's go here. Diversity. Just get a clear up understanding what diversity means. Brother Gray, read from here.
I can't see your screen. Oh.
You see it now?
Let me move my okay, I can see it now. Mostly in order for diversity jurisdiction to apply, complete diversity is required, where none of the plaintiffs can be from, be from the same state as any of the defendants. A corporation is treated as a citizen of the state in which it is incorporated and the state in which its principal place of business is located.
Stop. A corporation is treated as a citizen of the state in which is incorporated and the state in which its principal place of business is located. It didn't say a citizen is a citizen of the state in which is incorporated and the state in which is the principal place of business. It said a corporation.
True.
So what's going on with the citizens is a corporation can be citizens. They didn't just say corporations can be citizens in their state and their local place of business. Who else did they say? Go ahead and read, Brother Gray.
A partnership or limited liability company is considered to have the citizenship of all of its constituent partners and members.
For all those who need case law, there's no case law for you.
Yeah.
Support that. For the corporations located in their states and their local place of business, as well as partnerships. We got case law for that one. Johnson versus Columbia Property. This is their dice. So this shows you that there's a diversity issue between to who they claim you are a citizen of. Because you're not a citizen as a corporation of the state, are you?
No.
You're not a citizen of a partnership or limited liability partnership company, are you? Unless you want to be.
Not at all.
I'm pretty sure nobody wants to be. Read the next one, Brother Gray.
Thus, an LLC or partnership with one member or partner sharing citizenship with an opposing party will destroy diversity of jurisdiction. Cities and towns, incorporated municipalities, are also treated as citizens of the states in which they are located. But states themselves are not considered citizens for the purpose of diversity.
Stop. Okay. So it says there are three classes of citizens. The corporations and the states where they're incorporated, limited liabilities and partnerships, cities and municipalities.
Yes.
But they're all incorporated in the state.
Correct.
That's why they said the state cannot be considered in regards to diversity issues, because everybody incorporates into the state.
True that. They're part of the same culture. It's one.
They come from the same father, mother.
Yeah.
All right, that's key point. So it's our obligation as citizens or members or family members or partners, whatever you want to classify it, we have to make distinction between who we're citizens of and who they determine we're citizens of. Because we know that their citizens are not nationals. Their citizens are naturalized citizens whose origins goes back to colonists who are living on plantations.
Point of interest that this in particular speaks to what King Edward spoke of us knowing who we are and doing what to us should be done, and knowing who they are and let them do unto them.
Yes, sir. Yes, sir. Render unto Caesar what to Caesar's, and render on what God was God's.
Yes, sir.
See, we are God, but we're not abstract gods. We're lords, because lords were the ones who they went to for direction.
Yes, sir.
You had the House of Lords, you had the House of Commons. The House of Commons looked to the House of Lords for direction. But see, that time and era has been forgotten. That's called time out of mind. This is what I'm bringing back to you.
This was a switcheroo. This is them stealing the birthright. Yeah, this is them.
Okay, and how we know that? It just said diversity issue is not going to be considered on the state level.
Right.
Why?
There.
Because each and every one of us has been incorporated in this right here. Cities and municipalities.
Cities and municipalities. Yes, sir.
1790 District, it just said in nationality, it started in 1790 with the Nationality Act with the District of Columbia. The District of Columbia is not a state, it's a municipality.
Creature of the state.
It's a creature of the state. It was created by an act of legislature. It's called the Dillon's Rule. Now, the municipalities don't follow Dillon's Rule. They follow the Home Rule. Now, pay attention to those two key points I just said. Dillon's Rule, which means that if the municipality is to give a certificate of incorporation for citizens, it must be followed by the legislator. The Home Rule says that it don't have to follow what the legislator follows. Keep that in mind when you're dealing with us, because we don't go to the state for our local business, do we? We go right to the local government. That's the municipalities, your bureaus, the villages, the townships, etc. That's who you do business with. So if that's who you do business with, then that's who they're assuming you to be citizens of.
Yeah.
How you know that? Because you got the rights to the privileges and immunities of that citizenship. You can go to all the stores they got. You can go to YMCA, Sam's Clubs, you now become a citizen of Sam's Club.
Participation.
Participation.
Yeah.
All right, everybody on the same page.
Yep.
Yes,
All right, now we just said, in lieu of the virtue of jurisdictionship, which case law provides, it says that you are considered a citizen. And our citizen is based off corporations, because corporations run everything, and corporations were allowed to be here by what? Your cities through incorporation.
Mm-hmm.
That's what they did. So they not only incorporated the corporation, they incorporated you as the corporation. It just said it. A corporation is treated as a citizen of the state in which it is incorporated, and the state in which the principal place of business is located. And it's saying citizen. Why you ain't putting citizen in there? Because we trying to be citizens, so we don't define ourselves, because we're going to fall right in these categories right here. And every time they bring a claim against us, they're going to use this case law to support it.
Lump us into one.
Non-compos mentes. We're ignorant. How we know that? Let's see what the Supreme Court has to say about it, because we got case law qualifying it. Let's see what they saying and what we say. This case right here. This is State versus Manuel. Continue to read, Brother Gray. Let me just show you the case. State versus Manuel. Just to highlight this part. Come on, get to it. Oh, here we go. Start right here. Highlight the part.
Whatever distinctions may have existed in Roman law between citizens and free inhabitants, they are unknown to our institutions. Before our revolution, all free persons born within the dominions of the King of Great Britain, whatever their color or complexion, were native-born British subjects. Those born out of his allegiance were aliens. Slavery did not exist in England, but it did exist in the British colonies.
Stop, read that again. See, we rewrite over stuff, and it's case law tell you that you were enslaved by British minorities, because I don't care what complexion you were. In England, you were free. Now, we ain't over in England. This ain't case law from over in what they call Europe.
Yes, sir.
This is right here in what we call now the United States, talking about England. Read it again for me, Brother Gray.
Slavery did not exist in England, but it did exist in the British colonies. Slaves were not in legal parlance persons, but property. The moment the incapacity or disqualification of slavery was removed, they became persons and were then either British subjects or not British subjects, according as they were or were not born within the allegiance of the British king. Upon the revolution, no other change took place in the law of North Carolina than was consequent upon the transition from a colony dependent on a European king to a free and sovereign state. Slaves remained slaves. British subjects in North Carolina became North Carolina freemen. Foreigners, until made members of the state, continued aliens. Slaves manumitted here became freemen.
Sorry about that.
Become freemen, and therefore, if born within North Carolina, are citizens of North Carolina, and all free persons born within the state are born citizens of the state.
There you go, right there.
Now stop. Somebody, Brother Millinger, just mentioned the 1740 Act of North Carolina. So he just mentioned that, and it said specifically in that act that Berbers were to be enslaved. Not Africans, not whites, but Berbers in that act of settlement, the Slavery Act of 1740 in South Carolina. Continue to read.
a few only of the principal objections which have been urged against this view of what we consider the legal doctrine will be noticed. It has been said that by the Constitution of the United States, the power of naturalization has been conferred exclusively upon Congress, and therefore it cannot be competent for any state by its municipal regulations to make a citizen. But what is naturalization? It is a removal of the disabilities of alienage. Emancipation is the removal of the incapacity of slavery. The latter depends wholly upon the internal regulations of the state. The former belongs to the government of the United States. It would be a dangerous mistake to confound them.
Okay, now this is very important, everybody, because it's telling you right here that the state cannot grant citizenship by way of to the municipality. But I just mentioned Dillon's rule, and the Dillon's rule says that the state can grant legislation to the municipality, but it must confine or construe itself to the legislative act that it granted it. But some states have a home rule. That means that you can do whatever the hell you want. You can do whatever the hell you want. And as it just stated here, according to the Supreme Court, it said that municipalities can't make citizens, but that's what you're made through incorporation as your everyday business. Contract makes law.
Yes.
You indulge in the activity of the municipality, you just now declared yourself a citizen.
Consent.
Let's continue on. Back to United States nationality law. Right here. Start from, let's see who's next. Let's get Brother Scott from the House of Scott to read Expansion and Interpretation of 1866 to 1980.
In the aftermath of the Civil War, Congress enacted the Civil Rights Act of 1866, and later that year passed the 14th Amendment to the United States Constitution to grant citizenship status to former slaves. The language of the amendment was race neutral and granted nationality to anyone born in the United States who had no allegiance to a foreign power, but specifically excluded all Native Americans who adhered to tribal governance.
Not right there. So it just spoke about 1866 Civil Rights Act. Because we know prior to 1866, we were enslaved. We know that from Dred Scott case, right? Everybody know that.
Follow.
Now we talk about citizenship as established, as it said, from the Naturalization Act. Right here. Now read after 12. Now watch where it goes into Dred Scott case. Now when they talk about Dred Scott under Chief Justice Taney said that they didn't care if Dred Scott was free or not. He didn't have no rights that the Constitution was bound to protect because he was not a citizen pertaining to the Naturalization Act of 1790, which is just for white people. So Dred Scott's salvation didn't come until 1865, which didn't deal with slavery. It just dealt with him being, he didn't deal with citizenship. It was just dealing with him being emancipated from slavery.
Property.
Now we got to deal with citizenship because citizenship denotes the allegiance and protection. He didn't have that. What they gave him was civil rights.
All right.
All right. And we're just going to read it. Read after right here. Brother Scott.
It limited those who were eligible to be nationals as free white persons. Following the practices of English common law, the legal system of the United States absorbed covenanture, or the assumption that a woman's loyalty and obligations to her spouse were more important than her loyalty and obligations to the nation. While the Nationality Act did not forbid a woman to have her own nationality, judicial rulings and custom on domestic matters established that infants, slaves, and women were unable to participate in public life as a result of the belief that they lacked critical judgment and had no right to exercise free will or control property.
Stop. Now, what's happening? Look what the Supreme Court is doing right now. They're denying women their constitutional rights. I don't want to even get into that argument in regards to the subject matter, but as you can see, a display in lieu of what they call rights guaranteed by the Constitution, but we see you ain't got no rights guaranteed by the Constitution. They don't even pertain to you.
They just contradicted themselves.
Straight contradiction.
Yeah.
And then they said Native Americans considered to be the subjects of foreign government and per decision like Dred Scott. Foreign governments. What is the foreign government? We know Dred Scott was subject to the rules of the monarch. How we know that? Let's get into the subject matter. Let's go back to more case law. Before we do that, it mentioned freemen.
Yes, hyphenated.
Free men. And the term freemen was actually established by the House of Burgesses. The first General Assembly in Virginia, the colony. Now, when we were enslaved in 1865, emancipated in 1865, they gave us what we call civil rights under the Civil Rights Act of 1866. And they created, just like they created those agencies they have today called the alphabet agencies, they created agencies back then called the Freedmen Bureau. Mm-hmm. The Freedmen Bureau was created by an act or an agency. And let's look at who they're talking about. Just read the first two paragraphs for me, Brother Scott. Hold on 1 second.
Be it enacted by the Senate and the House of Representatives of the United States of America and Congress assembled, that there should be no discrimination in civil rights or immunities among the inhabitants of any state or territory of the United States on account of race, color, or previous condition of slavery, but the inhabitants of every race and color without regard to any previous condition of slavery or involuntary servitude, except as a punishment for crime whereof the party shall have been duly convicted, shall have the same right to make and enforce contracts, to sue, be parties, and give evidence, to inherit, purchase, lease, sell, hold, and convey real and personal property, and to full and equal benefit of all laws and proceedings for the security of person and property, and shall be subject to like punishment, pains, and penalties, and to none other any law, statute, ordinance, regulation, or custom to the contrary, notwithstanding.
Stop right there. So by way of the Civil Rights Act of 1866, the people who were emancipated in 1865 are looking to this remedy for due process of law, because it's telling you what the rights are in this time of the Civil Rights Act. Now keep this in mind, what they promised us in the Civil Rights Act, but I'm gonna show you a case law that what they promised wasn't based off for Dred Scott, because Dred Scott was not considered a citizen. He just was emancipated from bondage. Totally different. Citizenship is either by way of you being a national or being emancipated from being an alien to what they call a naturalized citizen, what they call national.
Your status.
Either a foreigner or a foreign national. Yes. I mean, an alien or a foreign national, which is a naturalized citizen, contrast to a national that comes from a nation, i.e. a country. And whereas Dred Scott didn't have any of that. But yet this man had a Scottish name, Dred Scott. He was emancipated in 1865, but didn't have no right in pertaining to property rights, because a property right is a right of inheritance. Everybody agree?
Follow.
Continue to read.
Section 2, and be it further enacted that any person who under cover of any law, statute, ordinance, regulation, or custom shall subject or cause to be subjected any inhabitant of any state or territory to the deprivation of any right secured or protected by this act, or to different punishment, pains, or penalties on account of such person having at any time been held in a condition of slavery or involuntary servitude, except as a punishment for crime whereof the party shall have been duly convicted or by reason of his color or race than it is prescribed for the punishment of white persons, shall be deemed guilty of a misdemeanor, and on conviction shall be punished by fine not exceeding $1,000 or imprisonment not exceeding 1 year, or both, in the decision of the court.
Read section 3.
Section 3, and be it further enacted that the district courts of the United States within their respective districts shall have exclusively of the courts of the several states cognizance of all crimes and offenses committed against the provisions of this act, and also concurrently with the circuit courts of the United States of all causes, civil and criminal, affecting persons who are denied or cannot enforce in the courts and judicial tribunals of the state or locality where they may be any of the rights secured to them by the first section of this act. And if any suit or prosecution, civil or criminal, has been or shall be commenced in any state court against any such persons or against any officer, civil or military, or other person for any arrest or imprisonment, trespass, or wrongs done or committed by virtue or under color of authority derived from this act, or the act to enlarge the powers of the Freedmen's Bureau, such defendant shall have the right to remove such cause for trial to the proper district or circuit court in the manner prescribed by the act relating to habeas corpus and regulating judicial proceedings in certain cases, approved March 3, 1863.
Okay, that's cool. So habeas corpus, produce the body. Produce the body. Because in regards to this court case, it clearly states here that they stipulate that due process of law for all parties, no matter what complexity you are, white and color. So we're assuming, or we were presumed to be on the same footing, right? If we read this document, we assume that we all had the same type of rights. Not talking about no constitution. Because remember, the Constitution don't give rights, it protects rights. But they ain't talking about the Constitution because the Constitution didn't have no rights for Dred Scott to be protected. Dred Scott didn't have any rights for the Constitution to protect. So they had to create some type of legislation, which is called the Civil Rights Act of 1866. And they also created what they call the Freedmen's Bureau, which was a part of that Civil Rights Act to deal with matters concerning free people of color. So let's get a scope on that. Freedmen's Bureau. Now, remember, it just said, in this case, it said district court or circuit court in the manner prescribed by this act. District court and circuit courts are trial courts. They're not appellate courts. The appellate court is an appeal court, and the Supreme Court is the last court of appeals. That's what they are. They're courts for judicial review. District court are for courts that establish for diversity issues, which is the case in point in regard to the diversity of the different citizens of different states in lieu of the civil rights. Now I'm about to show you a case law in 1866. In 1866, because as we just read here, where's that? Nationality. Nationality law was established here. No, where's that? Right here. The United States versus Wong Kim Ark. Under the 14th Amendment Nationalization Clause, the Supreme Court case United States versus Wong Kim Ark, any person on the United States soil is subject to its jurisdiction, it is a natural born citizen, regardless of parental citizenship. This type of citizenship is referred to as birthright citizenship. Everybody pay attention. Pay very close attention. Now let's go in depth. Let's go first here. Wong Kim Ark. We're talking about citizenship. Let's read this. Sister Harris from the House of Harris.
The very learned and useful opinion of Mr. Justice Gray, speaking for court, United States versus Wong Kim Ark, established that at common law in England and the United States, the rule with respect to nationality was that of the jus soli, that birth within the limits of the jurisdiction of the Crown and of the United States as a successor of the Crown fixed nationality, and that there could be no change in the rule of law except by statute. That by the statute of 7 Anne, extended by the statute of 4 George II. All children born out of the allegiance of the Crown of England, whose fathers were or should be natural born subjects of the Crown of England or of Great Britain at the time of the birth of such children, respectively, were deemed natural born subjects of that kingdom to all intents and purposes whatsoever. That statute was extended by the statute of 13 George III to foreign-born grandchildren of natural-born subjects, but not to the issue of such grandchildren. Dice conflict of laws. The later author says that British nationality did not pass by descent or inheritance beyond the second generation. These statutes applied to the colonies before the War of Independence.
And this is called Calvin's case, because Calvin's case dealt with the first birthright established here in North America called just soil, not just sanguineous. That's missing out of the equation because that's left for the English heirs. This is why Dred Scott found himself in the position that he was in, because there was no constitution in effect. There was only a Civil Rights Act created, because the Constitution didn't give any right and protect rights. But the Constitution of the original Constitution goes back to July 2nd, 1776. Which didn't talk about states. They had colonies back then. And in the last, what they call nullification provision of that Constitution in New Jersey, it states that the true intentions of Congress was for the reconciliation of Great Britain. And if that the colonies come back under the protection of Great Britain, the Constitution of July 2nd, 1776 will be null and void. That Constitution is null and void because under 16.1-28, rights stayed under the charters of Great Britain, saved from repeal. A charter is a certificate of incorporation. That's how the United States incorporated on England through incorporations called the Articles of Confederation. That was called what they call an Organic Act. Organic Act goes back to what they call treaties. The last treaty made with the United States was called the Treaty of Paris of 1763, when France and Spain ceded everything to Great Britain. And then in 1787, you had the Organic Act, or what they call the Treaty of Paris of 1707, when Thomas Jefferson and the founding fathers made all the Native Americans move west of the Appalachian Mountains and started deviating out the land on what they call free and simple. How we know that? Let's prove it. Let's go here. Let's read some more case law from this one. It has a lot of points here. This is still United States versus Wong Kim Ark. Oh, I'm sorry, I wasn't ahead. Gotta go ahead. All right, here we go. This is United States Wong Kim Ark. That's it. Let us have it. Okay, here we go. This United States versus Wong Kim Ark. We just read what they said about the United States, the successor to the crown. Now start from here. Sister Harris.
Minor versus Happeset, Chief Justice Wadi, when constructing in behalf of the court, the very provision of the 14th Amendment now in question said the Constitution does not, in words, say, who shall be natural born citizens. Resort must be held elsewhere to ascertain that, and he proceeded to resort to the common law as an aid in the construction of this provision.
Read that again. Everybody listen.
In Minor versus Happeset, Chief Justice Wate, when constructing in behalf of the court, the very provision of the 14th Amendment now in question said the Constitution does not, in words, say who shall be natural born citizens. Resort must be held elsewhere to ascertain that. And he proceeded to resort to the common law as an aid to the construction of this provision, 21 Wall 167.
Okay, so it's saying that Chief Justice Wade said, in regards to natural born citizen, the Constitution never really defined it. So he said, in order to understand what citizenship means in reference to the Constitution, we must look to the common law. So the common law, according to Smith, Alabama, says this. Read this, Sister Harris.
In Smith versus Alabama, Mr. Justice Matthews, delivering the judgment of the court, said there is no common law of the United States in the sense of a national customary law distinct from a common law of England as adopted by the several states, each for itself, applied as it is its local law, and subject to the subject alteration as may be provided by its own statutes. There is, however, one clear exception to the statement that there is no national common law. The interpretation of the Constitution of the United States is necessarily influenced by the fact that its provisions are framed in the language of the English common law and are to be read in the light of its history.
Okay, now here we have two Supreme Court cases in regards to establishing citizenship. And it said, it stated, Wong Kim Ark, United States versus Wong Kim Ark, is case law in regards to citizenship. And he said that the United States was successor to the crown and is fixed in nationality. And it said, in regards to this case, we're not going to determine what the citizenship means in the Constitution because it never really clearly defined what a natural born citizen was. So we must look to the common law, as Smith versus Alabama said, and that all the several states have adopted that common law as their local body of law, and subject to alterations as provided by their own local statutes. We're talking about the municipalities and the counties, y'all. That's what we're talking about. Your municipalities, your cities, your boroughs, your villages. The law they should be using in this day and time is the common law of England as established versus Smith, Alabama, if you're talking about citizenship. Because they just said, in lieu of diversity, citizenship can be in municipalities and counties as well. But it just said in State versus Manuel that you can't supposed not to do that. They don't allow that. But apparently that's what we find ourselves in that position. Continue to read, Sister Harris.
The fundamental principle of the common law with regard to English nationality was birthed within the allegiance, also called legality, obedience, faith, or power of the king. The principle embraced all persons born with the king's allegiance and subject to his protection. Such allegiance and protection were mutual, as expressed in the maximum protectio tahit.
Don't even worry about it. You can't get it, don't worry about it.
Okay. Thank you. And were not restricted to natural born subjects and natural subjects, or to those who taken an oath of allegiance, but were predictable of aliens and immediately. So long as they were within the kingdom, children born in England of such aliens were therefore natural born subjects, but the children born within the realm of foreign ambassadors of the children of alien enemies, born during and within their hostile occupation of part of the king's dominion, were not natural born subjects, but because not born within allegiance, the obedience or the power, or as would be said at this day, within the jurisdiction of the king.
Okay, so that means if you are foreign nationals that means you got an ambassador here to speak on your behalf. And if that's the case, that means you're not an English national and you're not a subject of the king. You're a citizen of the United States now, or a citizen of a foreign state, or as a foreign national. But you're not a subject of the king, because in the eyes of the common law, citizen and subject is totally different. How we know that, we're going to continue to see. Continue to read, Sister Harris.
This fundamental principle with these qualifications are explanations of it was clearly though quantity stated in the leading case known as Calvin's case, or the case of the Posnati, decided in 1608 after a hearing in the executor chamber before the Lord Chancellor and all the judges of England, and reported by Lord Coke and by Lord Ellesmere. Calvin's case, Ellesmere or Personate.
You skip all that.
Okay. The English authorities ever since are to the like effect.
All right, go to the next one. We're just skipping for the sake of time, but still dealing with Wong Kim Ark, because Wong Kim Ark sets the standard for citizenship here in North America. And we know that the citizenship we're seeing here in this case is two. One dealing with nationals of England and one dealing with nationals of what we call the United States, as determined because the Constitution never really defined it. They never really defined what the citizenship was. They just said a natural born citizen. All right, let's go down a little further. Another case law. Because remember, we're dealing with civil rights, not Constitution. Civil rights give you protections and Constitution give protections. But Dred Scott didn't have the protection from the Constitution. He only had the rights granted from the so-called Civil Rights Act of 1866. But we're going to watch how that act of 1866, according to United States versus Rhodes, was contradictory in its nature, which we're going to read after we get to this point. Read this point, Sister Harris.
In Dred Scott versus Stanford, Mr. Justice Curtis said the first section of the second article of the Constitution uses the language, a natural born citizen, and thus assumes that citizenship may be acquired by birth. Undoubtedly, this language of the Constitution was used in reference to that principle of public law, well understood in this country at the time of the adoption of the Constitution, which referred to citizenship to the place of birth. And this extent, no different opinion was expressed or intimated by any of the other judges. In the United States versus Rhodes, Mr. Justice Swanee, sitting in this circuit court, said, all persons born in the allegiance of the king are natural born subjects, and all persons born in the allegiance of the United States are natural born citizens.
Read that again. Read that again.
Okay, in the United States versus Rhodes, Mr. Justice Swanee, sitting in the circuit court, said, all persons born in the allegiance of the king are natural born subjects, and all persons born in allegiance of the United States are natural born citizens. Birth and allegiance go together. Subject is the rule of the common law, and is the common law.
Sorry, I apologize. 1 second.
No problem. Okay, common law, and it's the common law of this country, as well as England. We find no warrant for the opinion that this great principle of the common law has ever been changed in the United States. It has always obtained here with the same vigor and subject only to the same exceptions since as before the revolution.
Okay, so as it says, the United States versus Rhodes, as well as the Smith versus Alabama, that the common law of England has always been a law to go to in reference to establishing citizenship in reference to nationality. If you're not dealing with nationality, you're dealing with naturalization, then the law to go through is Calvin's case. Make sense? Any questions for anybody? I know I got some questions. Somebody got a question. Somebody, come on, I'm telling you, somebody, Brother Walkthorpe. Got a question, brother? Is he still there? You still there, Brother Walter? Nobody else got questions. Greetings, Brother Burgers from the House of Burgers. All right. I'm assuming everybody understand on the same page. So now it says that in United States versus Rhodes, somebody said something?
I was just saying.
Okay. All right. So as we can see, United States versus Rhodes, Justice Sweeney said, all persons born in the allegiance of the king are natural born subjects. All persons born in the allegiance of the United States are natural born citizens. Birth and allegiance go together, such as the rule of the common law. And we know Smith versus Alabama said the common law was adopted by all the several states, right? And it was looked at in the light of the history of that people. But ain't no people in regards to the common law, so they don't use that history. So therefore, the only history they use is that going back to Calvin's case that deals with naturalization by way of what we call denization, by way of a grant, such as the grant given to Dred Scott. So now let's go into a case, because it said United States versus Rhodes. Very important case. Why do I say that? Okay, right here. This is my focal point. United States versus Rhodes. In 1866, this was an indictment and violation of the Civil Rights Act, which was a bill in its constitutionality. It was an indictment needed to declare the existence or the provisions of a public statute upon the prosecution, which was founded. This was the case dealing with a lady by the name of Mrs. Talbot. Now, Talbot is an English name. It's an English name. The origin of Talbot is English, but they claimed that Mrs. Talbot was an African-American descendant, and the rights that she were protected by was based off the Civil Rights Act of 1866. Now, you see here, United States versus Godwin. The same surname my queen has, Godwin. All right, now this is case law. It says indictment for burglary and entering the house of T in Kentucky declared that T was an African descendant and a citizen, and that's used by law of Kentucky denied the right to testify against the defendant, they being white. There was a public statute of Kentucky enabling white persons under similar circumstances to testify. It was held that the indictment was sufficient and that the circuit court might take jurisdiction under Section 3 of the Act of April 9, 1866, known as the Civil Rights Bill, notwithstanding there was no longer declarement of the statute of Kentucky. The circuit court should take judicial notice of such statute, and indictment should be construed in some manner of the statutes were declared or at birth. A prosecution for burglary is a cause affecting the owner of the building entered within the meaning of Section 3 of the Civil Rights Bill, given the courts of the Union jurisdiction of all causes affecting persons who cannot enforce the courts of the state any of rights secured to them by the first section. If the owner of the building enter is on account of color incompetent by the law of the state where the offense is alleged to have been committed, to testify in support of the indictment as the right person might in the circuit court has jurisdiction. Let's get into the subject matter. The criminal jurisdiction conferred upon the circuit and district court by Section 3 of the Civil Rights Bill is not confined to offense committed by colored persons. It extends to prosecutions against white persons for offenses affecting persons who cannot enforce the state court the rights secured to them by Section 1.5. The Civil Rights Bill is not a penal statute. It is a remedial one and is to be liberally construed. The history of the adoption of the first 13 amendments to the Constitution and the object and proper construction of them explained. 7, free persons of color born within the allegiance of the United States are citizens and have always been entitled to be so regarded. Now, in the eyes of what we already discovered, when they say a national or naturalized citizen, they're talking about these free people of color. That's what they're talking about. They're not talking about national. And the basis they used was the Dred Scott case. The dictation to the contrary is Scott versus Sanford. Disapproved. The emancipation of the native-born slaves by the 13th Amendment removed the disability of slavery and made him a citizen of the United States, subject, however, to any lawful restrictions imposed upon his rights or other powers. Say it again.
Rights to vote.
Rights to vote or other powers or privileges. So let's get into the case at point. All right, Sister Allen, you can read. Who would just finish reading?
The Harris.
Sister Harris, Sister Allen, would you take over?
Yes. Arthur Wayne Circuit Justice. This is a prosecution under the Act of Congress of the 9th of April, 1866, entitled An Act to Protect All Persons in the United States in their Civil Rights and to furnish the means for their vindication. The defendants having been found guilty by a jury, the case is now before us upon a motion and arrest of judgment.
Stop. Now, a motion for judgment to arrest the person who violated the so-called African-American who had the surname of an English person by the name of Talbot. So this was a motion brought before the circuit court to arrest, but based off the status of her as the something of an African-American or a person of color, she was denied the right to testify on behalf of her matter in regards to the person who violated her rights in lieu of the protection granted by the civil rights. Anybody understand? All right, continue on.
3 grounds are relied upon in support of the motion. It is insisted, 1, that the indictment is fatally defective. 2, that the case which it makes or was intended to make is not within the act of Congress upon which it is founded. 3, the act itself is unconstitutional and void. As to the indictment of either account be sufficient, it will support the judgment of the court upon the verdict. Our attention will be confined to the second count. That count alleges that the defendants, being white persons, on the 1st of May, 1866, at the county of Nelson, in the state and district of Kentucky, at the hour of 11 of the clock in the night of the same day, feloniously and burglariously did break and enter the dwelling house there situate of Nancy Talbot, a citizen of the United States of the African race, having been born in the United States and not subject to any foreign power, who was then and there and is now denied the right to testify against the said defendants in the courts of the state of Kentucky and of the said county of Nelson, with intent and goods and chattels, monies and properties of said Nancy Talbot in the said dwelling house, then and there being feloniously and burglarously to steal, take, and carry away, contrary to the statute in such case made and provided, and against the peace and dignity of the United States. The objection urged against this count is that it does not ever that white citizens enjoy the right, which it is alleged is denied to Nancy Talbot. This fact is vital in the case. Without it, our jurisdiction cannot be maintained. It is averred that she is a citizen of the United States of the African race, and that she is denied the right to testify against the defendants, they being white persons. Section CC 9 of the Code of Civil Practice of Kentucky gives this right to white persons under the same circumstances. This is a public statute, and we are bound to take jurisdiction cognizance of it. It is never necessary to set forth matters of law in criminal pleading. The indictment is in legal effect as if it averred the existence and provisions of the statute. The enjoyment of the right in question of white citizens is a conclusion of law from the facts stated. Averment and proof could not bring it into the case more effectually for any purpose than it is there already.
Okay. All right. Now this is getting to the section. They're speaking about the first to the 13 sections of the Bill of Rights, in which they're claiming that Nancy Talbot had the right to in regards to testifying on behalf of herself in lieu of the infraction that was done by the white defendant when they broke into her house. Now, this is the judgment of the court, or the conclusion of what the court said. Okay. Now they get down to the 9th section. Now read what they say after the 9th section in regards to the Civil Rights Act that's supposed to be protecting all citizens once they were emancipated. But as we can see, in the case of Nancy Talbot, she wasn't granted the right to testify on her behalf because of her status, which afforded the white person the right to testify on their behalf is something of the same magnitude occurred on behalf of the other party. So now we, in regards to what we see on the basis in the founding of the Civil Rights Act of 1866, which also included the agencies that included what we call the Freedmen's Bureau. Now read what they say.
It is incredible that all this machinery, including the agency of the Freedmen's Bureau, would have been provided if the intention were to limit the criminal jurisdiction conferred by the 3rd section to colored persons and exclude all white persons from its operation. The title of the act is in harmony with this view of the subject. The construction contended for would obviously defeat the main object which Congress had in view in passing the act and produce results the opposite of those intended. The difficulty was that where a white man was sued by a colored man or was prosecuted for a crime against a colored man, colored witnesses were excluded. This in many cases involved a denial of justice. Crimes
Read that again. Read that again.
The difficulty.
Now remember, we're talking about due process of right under the Civil Rights Act in regards to people of color, because they know they didn't have no protection of the Constitution. That's what Chief Judge Taney said. So the only thing they can look to was the Civil Rights Act of 1866. But look what the status had in regards to the statutes that applied to all citizens, white or colored. The same political status that the white had was not the same consideration given to the color. Why? Because of their denotation to what we call citizens, which we're going to see in this case. Continue to read.
The difficulty was that where a white man was sued by a colored man or was prosecuted for a crime against a colored man, colored witnesses were excluded. This, in many cases, involved a denial of justice. Crimes of the deepest dye were committed by white men with impunity. Courts and juries were frequently hostile.
I'm sorry.
That's okay. Courts and juries were frequently hostile to the colored man and administered justice, both civil and criminal, in a corresponding spirit. Congress made these evils by giving to the colored man everywhere the same right to testify as is enjoyed by white citizens, abolishing the distinction between white and colored witnesses, and by giving to the courts of the United States jurisdiction of all causes, civil and criminal, which concern him, wherever the right to testify as if he were white is denied to him or cannot be enforced by the local tribunals of the state.
Wow. Now look, it gets deeper than that. Now look what they go on to say. Start right here.
The Act of Congress confers citizenship. Who are citizens and what are their rights? The Constitution uses the word citizen and natural born citizens, but neither that instrument nor any act of Congress has attempted to define their meaning. British jurisprudence, when so much of our own is drawn, throws little light upon the subject. And John,
You hear that? It says,
yes.
so no light on the subject. I wonder why.
Mm.
I wonder why no light being drawn on the subject, because why? They're the ones who were enslaving the so-called freemen, which were Anglo-Saxon Berbers. Continue on.
In Johnson's dictionary, citizen is thus defined: a freeman of a city, not a foreigner, not a slave, a townsman, a man of trade, not a gentleman, an inhabitant, a dweller in any place. The definitions given by other English lexicographers are substantially the same. In Jacob's Law Dictionary, 1783, the only definition given is as follows: citizens of London are either freemen or such as reside and keep a family in the city. And some are citizens and freemen, and some are not, who have not so great privileges as others. The citizens of London may prescribe against a statute because their liberties are reinforced by statute.
You hear that? Now, they're talking about are reinforced by statute, not case law, because case law is subject to change at any time. Continue to read.
Blackstone and Tomlin containing nothing upon the subject. The word civis, taken in the strictest sense, extends only to him that is entitled to the privileges of a city of which he is a member. And in that sense, there is a distinction between a citizen and an inhabitant within the same city. For every inhabitant, there is not a citizen. Common 677, a citizen is a freeman who has kept a family in a city. The term citizen, as understood in our law, is precisely analogous to the term subject, to the common law.
In the common law.
In the common law. And the change of phrases has entirely resulted from the change of government. The sovereignty has been changed from one man to the collective body of the people. And he who before was a subject of the king is now a citizen of the state.
Now, then we just said that. Now, it's just said that members, in the sense, there's a distinction between citizen and inhabitant within the same city. Now, we just said that we were incorporated into municipalities and that the state didn't have the authority to incorporate municipalities because the municipalities were based off freemen in the city of London. And we know London was a city in England. And we know England is a territory that we're subject to as citizens. Why? Because we are nationals. So if you're a national, you're a subject of the King of England. If you're a citizen, then you're a subject, you're a citizen of the United States, because the United States is successor to the crown, as we read in the case law. What was it? Wong Kim Ark versus United States. Wong Kim Ark is a successor to the crown, and it's fixed off nationality. So you have to have a nationality, but in the true sense of the word, not in the abstract meaning that was brought over here by the colonists, which is a form of naturalization. So everybody in the United States are considered national based off naturalization because you have now been naturalized into the citizen of a foreign jurisdiction, which is not legislatively constructed because they must go back to the organic law that is derived this authority from, which is the chart. How do we know that? Let's read a little bit further. Read right here.
All persons born in the allegiance of the king are natural born subjects, and all persons born in the allegiance of the United States are natural born citizens. Birth and allegiance go together. Such is the rule of the common law. and it is the common law of this country, as well as of England.
Read that again. Read that again.
All persons born in the allegiance of the king are natural born subjects, and all persons born in the allegiance of the United States are natural born citizens. Birth and allegiance go together. Such is the rule of the common law, and it is the common law of this country as well as of England.
What?
What?
What? Is this England or what?
It's England.
There's no way you can deny that we're not standing in England. It just gave you both so you can make sure that you know what they're talking about. All persons born as subject to the king by way of allegiance, because allegiance denotes to citizenship, and from citizenship comes your protection as a subject of the King of England. And that's well known in the United States, because he just said that United States is successor to the crown, and it's fixed off nationality. So if you have a nationality, that means your allegiance must be to the crown, which is the king. If you don't have a nationality, that means you are near national, which means you're a naturalized citizen, which you're a foreigner, which was brought over by the British monarch system, which enslaves you, because that's where slavery comes from. Same thing. They call it slavery. We call it slavery. They call it subject. Now they switched it from subject to citizen. Why? Because now they gave up the subjectivity under slavery, under the British monarch, and put that karma on the United States. How do we know that? I just said it. The children of ambassadors are theory born in the allegiance of the power of ambassadors, represent slaves, and legal contemplations are property and not persons. Read that one again.
Where am I starting? Okay, so start from the the children of the ambassadors.
All persons born.
All persons born in the allegiance of the king are natural born subjects, and all persons born in the allegiance of the United States are natural born citizens. Birth and allegiance go together. Such is the rule of the common law, and it is the common law of this country as well as of England. There are two exceptions, and only two, to the universality of its application. The children of ambassadors are in theory born in the allegiance of the powers the ambassadors represent, and slaves in legal contemplation are property and not persons.
Let's go back to our last lesson. When you're talking about the Commonwealth, are you talking about sovereign states headed by a head of state, whether they're Queen Elizabeth II or Joe Biden? They are foreign nationals. They are foreign nationals. Why? Because you're dealing with, it just said Calvin's case. Right there. Continue on.
The common law has made no distinction on account of race or color. None is now made in England, nor in any other Christian country of Europe. The fourth of the Articles of Confederation declared that the free inhabitants of each of these states, paupers, vagabonds, fugitives, from justice excepted, shall be entitled to all the privileges and immunities of free citizens in the United States.
Hold on. Hold on. Now, you mean to tell me these are the ones who claiming we descended from? Paupers, vagabonds, fugitives from justice, and everybody else? These are the citizens of the United States. Because as we said, dealing with territory of the United States, they were done by way of what we call incorporation. And the incorporation goes back to the Articles of Confederation, which was based off an Organic Act in 1777. It just mentioned the Articles of Confederation, which was made up of nothing more than the free inhabitants, i.e. citizens, who are i.e. foreigners, and these were nothing more than paupers. I didn't say it, they said it. Vagabonds, fugitives from justice. Why? Because they're not operating off the justice system. Continue to read what it says.
On the 25th of June, 1778, when these articles were under consideration by the Congress, South Carolina moved to amend this fourth article by inserting after the word free and before the word inhabitants, the word white.
Read it again.
Yes.
This is case law, y'all.
Yes.
This is case law. There's a diversity issue from the jump. We're not citizens. First of all, if you even bring me in the court of law, are you saying I'm one of your citizens? Because it's definitely a diversity issue because I'm not a corporation. And we know everybody get their citizenship, just like partnership, corporations, states, etc. It's by way of incorporation. So the only way my rights can be protected is by way of incorporation. But what you incorporated don't entail my rights. So what laws that were incorporated entails my rights? We got to go back to those charters. 16.1-28. Rights seen under the Charters of Great Britain saved from repeal because charters is not a government. It's just authority and starts for the government for your authority, which is a license. Our articles of incorporation is the same as the certificate of incorporation. It's a charter. Continue on.
Do you want me to read that sentence again?
No. Continue on after that.
Okay. The vote of one was divided. Scott versus Sanford, 19 Howe. When the Constitution was adopted, free men of color were clothed with the franchise of voting in at least 5 states and were a part of the people whose sanction breathed into it the breath of life.
Read that again. Hold on. You mean to tell me prior to that breath of life, I was dead?
Mm.
You mean to tell me Dred Scott was dead prior to that Civil Rights Act of 1866? Because that's what it's telling you. It said, State versus Manuel clearly stated that municipalities don't have the authority to incorporate citizens. Why? Because the states do not even be considered in lieu of diversity as a citizen. Why? Because they're the ones who incorporated the municipality. And the municipalities are the ones who incorporated the citizen, like Dred Scott. So if Dred Scott was incorporated as a citizen, then that means that he's no longer a free man. His life hangs on the breath of the legislator. As I said in Dillon's rule. Dillon's rule is life breathed into the legislator, which is the municipality. Municipalities are governed by Dillon's rule. It says that the legislator breathed life into the municipality, and it was that legislator that can take that life from it. So just like the legislator breathed life to the municipality, we're taking it back. Why? Because we're the free men of those municipalities. Because back then they weren't called municipalities and counties, they were called shires, they were called hundreds. Those are the terms we use in our parishes, i.e. by the clergy. Read the next paragraph and we can take a little break. Read that part right there.
Citizens under our Constitution and laws means free inhabitants born within the United States or naturalized under the laws of Congress. We find no warrant for the opinion that this great principle of the common law has ever been changed in the United States. It has always obtained here that with the same vigor and subject only to the same exceptions since as before the Revolution.
Okay, now they're telling you, when they got the Dred Scott case, it was a whole different issue. Because they're not addressing the political status or the citizenship of a national that's a subject to the king. They don't need to bring up case law dealing with that because his status does not reflect that. Remember, if you don't have personal jurisdiction, you don't have subject matter jurisdiction. Because jurisdiction means declared law. What law are you using? Now we're going to show you that in lieu of this decision in United States versus Rhodes, look what the court decided in lieu of there telling you that the common law of England is the same in England in regards to citizenship for English nationals, but not naturalized citizens in lieu of Calvin's case. And look what they close out and say in the case. Now, this is just a circuit court, and the district court, not the Supreme Court, because we know what the Supreme Court already said about it, that the United States was successor to the crown and it's fixed in nationality. Now look what they say in this case, in closing. Did I save it? Hold on. Right here.
It's passed by Congress.
No, start from there. Oh, see, it's lighting up. It's lighting up now. All right. Start right from there.
The amendment reversed and annulled the original policy of the Constitution, which left it to each state to decide exclusively for itself whether slavery should or should not exist as a local institution and what disabilities should attach to those of the servile race within its limits. The whites needed no relief or protection, and they are practically unaffected by the amendment. The emancipation which it wrought was an act of great national grace and was doubtless intended to reach further in its effects as to everyone within its scope than the consequences of a manumission by a private individual. We entertain no doubt of the constitutionality of the act in all its provisions. It gives only certain civil rights. Whether it was competent for Congress to confer political rights also involves a different inquiry. We have not found it necessary to consider the subject. We are not unmindful of the opinion of the Court of Appeals of Kentucky in the case of Brown versus Comp. With all our respect for the eminent tribunal from which it proceeded, we have found ourselves unable to concur in its conclusions. The constitutionality of the act is sustained by the Supreme Court of Indiana and the Chief Justice of the Court of Appeals of Maryland in able and well-considered opinions. We are happy to know that if we have erred, the Supreme Court of the United States can revise our judgment and correct our error. The motion is overruled and judgment will be entered upon the verdict. Motion overruled.
Okay, so they're telling you it's not our place to decide matters that were given to us by the legislation, because they go by the Constitution. At that time, Constitution to protect the status of Negro, Black, color Ethiopian. They only do something to the rights of the Bill of Rights, and the Bill of Rights, it really went toward the benefit of the true naturalized citizens versus those who were granted citizenship by way of the 14th Amendment. And then they grant the privileges for their defense, then come to 1866. Make sense to everybody?
Yeah.
Okay, so let's take a 5-minute break, and then I can come with the second part, which will be quickly, it'll be real quick. But what do you guys think about first part of the lesson in regards to true citizenship? Everybody can give 2 minutes to say a couple of words. Sister Alice.
Put it back on everybody's face so you can
Yes,
see.
I'm here. This was a very in-depth article that takes you further into the mindset of the people at that time. And this still holds true to this very day. How there's such gray areas involving the citizenship of Blacks in this country versus whites, you know. And this here is definitely something that we can use for future reference in going forth in our in claiming our nationality, pulling these case laws and bringing them to light. You know, we're the only ones that can change this. We're the only ones that can truly breathe life into these laws that have subjected us to slavery before and after the civil rights movement. With that, I digress.
Well said, well said, well said. Brother Walthor from the House of Walthor.
Yes.
What is your take on the first part of today's lesson?
I got some of it. I had lost, my computer went out, so I didn't get it.
I figured that.
The nationality endeavor that you were discussing today is just a highlight of, as the sister just brought out, of where we are, why we haven't been able to bridge over from slavery to where it should be now. We're still considered slaves. And so since we are of natural, as we were always here in England, we, like the sister said, we just have to bring that, we have to put that on notice and let them know, hey, we never left here. Y'all just disguised us as someone else, but no, we know who we are now. So I think that's the importance, and I'm sure we will gain more information as we continue.
Well said, Brother Walthor. But your counsels like to say a couple of words, or she'll digress.
I digress.
Okay, it's okay. Sister Militant from the House of Militant.
Yes. This is where the rubber meets the road, where it gets really kind of funky as I do my research in South Carolina, and I'm looking at Ancestry, the whole issue of free people of color versus slavery, and a lot of stuff was hidden. And even in terms of doing Ancestry, it's not necessarily clear or distinct who is quote unquote white and who is quote unquote Black. Even when it comes to plantation owners, it's as well as in terms of what we call the Civil War, whose side was people on? It's can be a little painful when you find out the truth. And I digress.
Well said. Sometimes the truth hurts. Well said, Sister Middleton. We have next Brother Gray from the House of Gray.
Yes, one of the things that stood out to me particularly was the United States versus Rhodes, where clearly states that birth and allegiance go together, and that allegiance to the king was a natural born subject versus a natural born citizen. And this, like Sister Allen had spoken earlier, this has been plaguing our people for so long for being categorized as Negro, colored, Black, and also not having allegiance to a king. So that was the main thing that I got out of it.
Well said, Brother Gray from the House of Gray. Brother Scott from the House of Scott.
Well, King, I know you stated about that we at some point will have the opportunity to argue the diversity of citizenship, but I'm a little confused. What's the difference? I mean, how does that separate us from walking into a courtroom and the court is under the assumption that we are property? And you stated that we will have to use diversity of citizenship sometimes to, I have to assume, to defend ourselves. So I'm a little confused.
Let me just give you a quick example. Just say you go into court and you get a summons in the mail.
Okay.
If you respond to the subject matter of the summons, you admit you're in their jurisdiction. Because you're saying that you're arguing the subject matter when they don't have jurisdiction over you as a person. Why? Because citizenship. First of all, who is the officer to stop you when he has not proven that he has the right to stop you as a citizen? Because diversity is an issue in this courtroom. You are limited in your capacity as a municipal officer. You can have it established as I'm a citizen of the municipality, the county, or the state. And neither of you deal with nationality. So there's clearly a diversity issue. You got to prove that I'm a citizen in which you can even talk about subject matter giving me a ticket. Because the jurisdiction in regards to a court of law is that, who are you? There's a diversity issue. You use the same law we just used. Diversity issue, it says, according to my understanding, municipalities can have citizens as well. Am I right? Then they also say that corporations can be citizens in their state where their local place of business as well. Then they say that as well as partnerships and limited liabilities as well. So now my question to you, which one do you assume me to be? Because I got a box right here that says I'm an English national. So now you got to hold me according to these standards, because in my certificate of corporation denotes to my allegiance, which is my citizenship. Now, are you telling me my allegiance to this municipality? Because if I am, then that means that I'll hold a public trust.
It's 3 o'clock.
You show me my oath of allegiance to the municipality.
Mm-hmm.
My oath of allegiance is to my nationality, which is my nation, which is my country. You don't even have a nation. You don't have a country because you don't know who you are. Who are you as a citizen to bring a claim against another citizen? That's a diversity issue. I'm a citizen. I can prove I'm a citizen. Why? Through my certificate of incorporation.
So is it necessary to prove
a driver license,
mm-hmm.
a registration, or anything like that? Because that's the first thing they ask for you, driver license, registration. If you pull that out, that means you're a citizen. They can proceed. Now you can have that driver license in your pocket and it can be expired. It's an ID, please. You hand them your ID from the temple and say, that's who I am. Now, this way you're acquiring a birth certificate or a driver license does not denote the citizenship. Why do I say that? Because it don't denote to a nationality. If you don't have a nationality on it, then how am I protected as a citizen? Because I have to be protected in the country that I am. The municipality is not a country. Is it?
Oh, it's
the
not.
The county is not a country. Are you protecting my citizenship? If you're not, then there's a diversity issue. Because that's a violation of my civil rights. You deprive me of my nationality, and my nationality is based off my citizenship to my country. And my country and my citizenship is based off my allegiance. So my allegiance to you, the city, municipality, or the county, or the citizenship is to my allegiance to my nation. That ain't for me to determine. That's the court to determine that. That's why I was moved to a district court for diversity of citizenship, because now you're discriminating against me. You can't prove I'm a citizen of the state. You can't prove I'm a citizen of the municipality. The only thing you got to prove that is a damn driver license. And they don't say nothing about citizenship on that driver license. So that made me a citizen of that corporation, because they can be citizens as well. There's case law to support that. And I'm telling you, that case law is not the case law I'm using. Why? Because under the case law, it's that the only law that's adopted by the several states, and any state I'm at, it's the common law of England, which should be read in light of that history of the common law of England that you adopted. So if you ain't using this common law, what law are you using in this courtroom? And I'm pretty sure it's not the common law of England. Why? Because I'm a citizen of England. How I know that? 61-28. How I know that? The certificate of incorporation. That's what? Article 12. That's where your rights come in, through your certificate of incorporation. They did it with their natural, what the Nationality Act of 1790. That's not where your citizenship is in the Act of 1790. Your citizenship is not with the Act of 1740. Your citizenship has always been here through time immemorial as a subject of the king. Why? Case law just said it. It's the law of this country and the law of England, which is one and the same. If the United States is successor to the crown, because the crown is England. You call it England, we call it Great Britain. One and the same. Now that's how you defend it. You're not even talking about the ticket now. They still got to prove, and then the court ain't gonna say nothing. It's gonna be that prosecutor. And the prosecutor is just gonna dismiss it because he can't go into that argument. Ho. How you got the authority to even give me a ticket driving in England? Well, when you driving on the street, no, I was driving on the land. You call it street, I call it the land. If you call it a street, then that confine me to space and time. When I say land, I can go anywhere. Why? Because my permanent place of abode determines my citizenship. And my permanent place of abode is not a state, it's not a municipality, it's not a county. It's the Kingdom of England. That's how you talk in the courtroom. They can't say nothing. It was held in the land trust under the trust doctrine, which goes back to the Magna Carta. Article 4 of our certificate of incorporation. And under the Magna Carta, if a land trust, it didn't say street trust, it didn't say avenue trust, it didn't say lane, it said land trust. And land trust denotes to the natural resources. So anything on this land, I have a right to it because it's held in trust. And that includes the natural resources on it, above it, and on top of it. That's how you talk. They start talking about that limitations, you lack jurisdiction here. There's a diversity issue. You got to prove that I'm a citizen of the municipality. And according to what we just read, it can't be conferred to you. Why? Because it was the legislation breathed life into you, and it was the legislature that could take it away. You're not even legislatively constructed because the legislation is confined to the Constitution, and the Constitution is true to the common law. And as Smith versus Alabama said, all the states adopted the common law of England. You keep it in that argument, they can't go nowhere. Did I answer your question?
That answered my question, King. Absolutely did.
All right. Any more questions? Who are we at now? Sister Harris.
Yes, this is a very, very meaty, hearty presentation today. A lot to really, really focus on. And it goes back to what the ancestors used to always say, what do you stand for? And it was always incomplete. What do you stand for? And we, that we're learning today that you're bringing to us, you're bringing it clear what we should be standing for, which is the crown land. Our allegiance is to the king. But we've been taught something differently, and we don't know what to look at. And I am grateful that you, the queen and the king, are bringing this information to us. So I have to really, really go back and really, really take my time and really be able to articulate this the way you do. So
thank you very much. It took time for me. As you said, crown land is what? Intel. It goes by operation of law, just like hereditaments, a birthright. Now they said citizen is a birthright. Didn't they say that? It's a right, not a privilege. Didn't they say that? So if it was a right for Dred Scott, why he got privileges? And he didn't even get the right for the privileges that they granted, because the Constitution don't give any rights, it only protect rights. So that means that if you got any rights that better be protected, it better come before that Constitution. And we precede that Constitution because it was for them, not us. All right? Sister Walker from the House of Walker. Go ahead, sister.
Greetings, King. I'm loving the lesson. I had to pull out my New York State Constitution. I wanted to read something real short, if I may. Yes. It says, and I believe everybody should read their state constitution. Whereas, this is from April 1777. It says, whereas the many tyrannical and oppressive on the rights and liberties of the people of the American colonies has reduced them to the necessity of introducing a government by Congresses and committee as temporary expedients. So these states are only temporary. Yes. And to exist no longer than the grievances of the
was instituted for the protection of the people. It didn't say the people instituted the government for themselves. It said they instituted the government to protect for the people. But what people? Because our ancestors already instituted the law for us. But they're not using that law. And what law is that? I want everybody to say that one time.
Common law.
That's what I'm talking about.
Common law.
Everybody clap their hands. Common law. All right. Let's have brother Scott. Did you go yet, brother?
No, I didn't
Oh,
finish.
you finished? You weren't finished yet.
No, I'm not
sorry.
finished.
I
I
apologize.
got one more paragraph, and it says, whereas the present government of this colony by Congress and committees were instituted, while the former government under the Crown of Great Britain existed in full force. It says the Crown of England existed in full force and was established by the sole purpose of opposing the usurpation of the British Parliament and was intended to expire upon reconciliation with Great Britain. So I don't know how you can be a citizen of the state, and the state has only been temporary, and the British Crown is in full force and permanent. So that's in the New York State Constitution. So once again, King, and then we go back to the state versus Manuel, the municipalities can't create citizens. So we're on this because we went to public school and this has been put upon us and we haven't been taught. So now we're learning true law and we're getting to the meat and potatoes. So thank you once again, King.
You're welcome. You're welcome, Sister Walker from the House of Walker. Brother Moonday from the House of Moonday.
Yes. Hold on, acting up. Hold on.
Take your time.
Thank you. Peace and greetings. I enjoyed the lesson today. I learned.
We ain't finished yet. This is part one. We ain't finished.
Oh yeah. Okay. Yeah.
Part one.
I learned, a few differences between the nationalities that I didn't know before. Summed up a few key points on that. So it's definitely
Thank you, Brother Mundi. You're
lesson.
breaking up. I didn't hear that last part.
No, I said it's definitely a great lesson.
Thank you, brother. Appreciate the gratitude.
Key points I need to understand about.
Yes,
Okay.
yes. Thank you, brother. Thank you. Brother Earl Burke, it's good to see you this morning, Noble.
Same here, King.
Hold on. I forgot my Sister Middleton from the House of Middleton.
Oh, yes, I spoke before.
Oh, you did?
Yes.
Oh, okay. All right. I just want to make sure I didn't miss it. Did I miss any countesses?
No.
Okay. My queen, I'm gonna let her go last. She's gonna close up shop for me for the break. Let's have who else was it? Who else? But Milligent from the House of Milligent.
Yes, King. Yes, King. Good thing there. In the education system, we know nothing prior to slavery.
I didn't hear you, brother.
I'm saying prior to enslavement or slavery, we don't know nothing beyond that. Like an empty vessel. So, let alone knowing about the Kingdom of England that we were part of even before. So that's a big problem. So that's a hard, from the Africa story here in the Kingdom of England. I mean, we know that, but for the average person, that's light years out of mind. So, last week we had a thing about the Clovis people and the Merovingian dynasty and all that.
Yes, sir.
So,
speaking to the phone.
Yeah, little thing. When if you look at the movie Matrix, not the first one, I believe it was the second one. One of the characters in it, he was the Merovingian.
Yeah. I'm gonna make sure I watch that.
Yeah. So you know what I'm saying? It's just crazy. Oh, you know what I'm saying? Everything crisscross and connected and coming together as a whole, you know what I'm saying?
Full circle, brother. Full circle.
Next, I got something more.
Thank you, brother. Thank you, Brother Millicent. Brother Means from the House of Means.
Yes, sir. I'd like to say thank you, first of all. Your layout was tremendously plain. It made it easy to follow. And to come back off of basically what everyone was saying is that the separation and the hidden identity for us not being able to articulate to defend ourselves, even in their statutes and laws, or even their codes, the truth is in there, which is in every case that was used in this presentation. I see now, I guess in the 17th century, when they made it unlawful for our people to read, is them hiding this jewel, because if we were able to read and comprehend what we were reading, we would have been able to defend ourselves and come out of this fog way prior to this situation that we're in right now. And it's speaking on the fact that you made the when you were alluding to defending ourselves in court, which we don't have to if we stop at the point of jurisdiction. And correct me if I'm wrong, for a court to any court in this land that they call in the United States, which is not the land, it's just a corporate fiction. For them to move forward, they need three to choose for them to say I have jurisdiction. They have to have the venue, subject matter,
yeah, subject matter. Yeah, what's it? Venue, subject
venue,
matter.
subject matter.
Any of that.
Yeah.
And venue is color. Their law is color, so they have no subject matter.
There it is, yes, sir. So if
nothing.
You don't argue the subject matter. You just stop them with the jurisdiction of. First of all, do you even have jurisdiction of the venue, which we know that's their court? But to be over me, you have to say, hey, prove that I am the citizen that you claiming I am, which I am not. Because the reason with Dred Scott was he was unable to articulate his citizenship to them. That way, he had no defense. He couldn't distinguish who he was, being that he was a slave. So he was unable to read. He was to read in his defense the laws that were predicated for him in his time. So I thought the citizenship factor in the subject matter in the subject was great to show how they took us out of our proper place and placed us in a fictitious place to have rulership over us, to blind us to the fact of who we are. This is the way that they were able to use us as money, because basically it all comes down to currency. If they're using you as currency to feed off of you to keep the beast going. And now that we can see that, the walls will fall. Being that we're coming forward and claiming, hey, this is who we are. We have to state who we are, because if you don't state who you are in any legislation passed, if you don't debunk it, if you don't try to break down that wall, it stands in law. So
yes.
Well said.
That I thought was what a wonderful way you placed it for us to go back and reiterate who we are and insert our rights that was given to us from the time immemorial.
Well said, brother.
Well said, Noble.
Who that? That's our Archbishop.
Thank you.
Yeah, that's me, King.
All right, my man. All right. All right, man. You made it. I'm glad. You can keep him back.
Greetings, Archbishop.
Greetings, everyone. Yeah, I just had to take a nap, and I took a couple. I normally don't take meds, but I had to take something this time. I feel much better.
All right.
Great.
Yeah. So yeah, I'm glad to see everybody here. I was listening to the whole lesson, and King, you did once again. You do a bad job, man.
That's how I do. I ain't finished yet. Wait till part 2. I'm gonna blow your mind.
Yes,
all right, that's gonna be quick though. I ain't gonna hold you all that long. So I just want to read this part. Brother Means, read this for him right quick.
Sure. Let me move my screen.
Hold on. Did I get everybody's chance to say a couple of words? Okay. All right. Go ahead, Brother Means.
All right. The right of the king to make this grant, with all its prerogatives and powers of government, cannot at this day be questioned. But in order to enable us to determine the nature and extent of the interest which it conveyed to the Duke, it is proper to inquire into the character of the right claimed by the British Crown and the country discovered by its subjects on this continent, and the principles upon which would the parcel out and granted.
Read that again.
The right of the king to make.
This is the public trust doctrine.
Yeah.
Dealing with the land. All right. This goes back to the Magna Carta, written by John, son of Godfrey, John, son of Henry, son of Godfrey, fifth caravan Jew, where I descend down from, where all the agnatic succession and lower birthright goes to, based off just sanguineous blood birthright. So if you are part of this heir and estate, you better go back to this blood. And this is based off what's being said here, and that the British Crown discovered it, not by conquest, because that was done by the House of Tudors. Discovery is done by what we call what we call King James done, and then it was implemented or continued by the founding fathers. Now continue what it say.
Continue, or you want me to reread?
Yeah, reread that again.
Sure. The right of the king to make this grant, with all of its prerogatives and powers of government, cannot at this day be questioned. But in order to enable us to determine the nature and extent of interest which it conveyed to the Duke, it is proper to inquire unto the character of the right claimed by the British Crown in the country discovered by its subject on this continent, and the principles upon which it was parceled out and granted. The English possessions in America were not claimed by right of conquest, by right of discovery. For according to the principle of international law, as then understood by the civilized powers of Europe, the Indian tribes in the New World were regarded as mere temporary occupants of the soil, and the absolute rights of property and dominion were held to belong to the European nation by which any particular portion of the country was first discovered.
Now listen what it says. It said the English possessions in America were not claimed by right of conquest, but right of discovery. Now who discovered? Not the English, we was already here.
Yes, sir.
The British. So all these territories are called possessions of the English. They've always been ours. How do I know that? Let's go back a little further. Finish with this, Brother Means.
Okay. And I can discover nothing in the authority given countenance to the idea that the king held the land covered by waters of a navigable. Can't see that.
I'm sorry.
Just touch down a little bit for me. Yes, sir. Navigable of a navigable river as trustee, or by the tenor different from that by which he held the dry land. And I must again repeat, if the king held such lands as trustee for the common benefit of all of his subjects, and inalienable as private property, I am unable to discover on what ground the state of New Jersey can hold the land discharged of such trust, and can assume to dispose of it to the private and exclusive use of individuals. If it was a trust estate in the king for the benefit of his subjects, and upon the revolution, the government of New Jersey reclaimed the trustee in the place of the king, and the trust devolved upon such government, and the land became inalienable in the government of New Jersey as the hands of the king, and the state must be bound to hold all such land subject to the trust, which, as contended, embraces a common right of fishery in the waters and the dredging of the oysters in the land covered by the waters. And if this so be, there certainly can be no power in the state without a breach of trust to deprive the citizens of New Jersey of such common right and convert these oyster grounds to the private and exclusive use of individuals.
Bingo. Bingo. This y'all land, brothers and sisters.
Yeah.
It's already yours.
Yeah.
You just got to be in the position as a beneficiary. It was created by the Statutes, by the ones who conquered your land, which was the House of Tudors, and then act like it was discovered by the monarchs, and then rediscovered by way of easement by the United States. This is all ours. How I know that? I'll see you in part 2. 5 minutes, everybody take a break, get your popcorn, get your peanuts. See you in a second, all right?